Good day, ladies and gentlemen, and welcome to the Employee Benefits broadcast. At this time, all participants are in a listen-only mode. If anyone should require assistance during the conference, please press star then zero. I'd now like to turn the conference to your host, Mr. Isaac Morris.
Well, welcome everyone to our second Employee Benefits broadcast this year. My name, again, is Isaac Morris, and I'll be reviewing some housekeeping matters and taking care of just a few introductory items before we get started. So these are the standard housekeeping issues that we always cover. Hopefully you won't need any tech assistance during this broadcast today, but if you do, please call 866-493-2825 and someone will help you. Again, that number is 866-493-2825. And in a like manner, if you need any audio assistance, go ahead and dial *0 and someone will assist you with that. If you want to ask a question, and we do encourage you to submit those, use the pull-down Q&A menu to submit the question. And if we have time at the end of the broadcast, we'll try to answer all the questions then. If not, if we run out of time, we'll follow up with you by an email after the broadcast ends. Three other quick items to cover is that, one, you have the ability to maximize the PowerPoint presentation by hitting F5 on your keyboard. Two, you also have the ability to print the presentation by clicking the printer icon in the lower right-hand corner of your screen, converting the presentation to PDF, and then printing as usual. And then finally, I guess two things finally. First, we hope that you'll take the time to complete the quick survey at the end of the broadcast and provide us with your feedback. We value that greatly. And then the last thing before we get into the meat of our broadcast today is that if you're applying for HRCI or CLE credits, please make sure that you're logged into both the audio and web portions of the broadcast. So we have a great mix of topics today, topics that include items that we're seeing on a regular basis, as well as some issues that you're going to see on a regular basis if you haven't so already. First up, Galen Mason from our Chicago office will speak about mergers of 401k plans and the questions that you really want to think about and consider before you make or undertake those mergers. As Galen is going to note, if you don't think about those questions, it's very possible that the IRS may do so for you. After that, Josh Agan, who is in our Milwaukee office, will talk about safe harbor 401k plans and how there are really a lot of issues lurking beneath the surface than may seem at first blush. And then finally, Robert Goldstein from our San Diego office is going to discuss and cover some new as well as some continuing issues with respect to fiduciary duties of 401k plans and fiduciary duties in general. And with that, I'm going to turn things over to Galen. Galen?
Thanks, Isaac. As Isaac mentioned, I'm going to be talking about some issues that can arise when you merge an acquired 401k plan into your plan. And this is Foley, the Foley practice group here, getting together and talking about some things that we see occasionally, and every once in a while we get a few that pop up that kind of surprise us that our clients may be dealing with repeatedly. So this is one of those hidden issues that we thought if we could talk a little bit about on a benefits broadcast, and we get an informal view about it, and an ounce of prevention is worth a pound of cure, so they say, so we can hopefully help you avoid it. So let me flip. So many of our clients are involved in buying and selling businesses, and this of course means, depending on the nature of the deal, there's typically two types of deals: asset deals and stock deals. We'll be talking about stock deals here today, where you essentially buy all of a company and all the benefit plans that come along with it. But essentially, when you do a stock deal, you acquire a 401k plan. Now, you still have some issues. You still have some options you can use to avoid handling, or options you can use in terms of how you're going to handle the plan. So the first option, and there's about 3 options. The first 2 we're going to touch on today and would be preferred, but the third, the acquire and merge, is the most common. Pre-close termination, the easiest thing to do is always to force the seller in a stock deal to terminate the plan prior to close. So they take that action, and you as the buyer don't necessarily have to deal with taking the plan onto your watch and merging it into your plan or keeping it generally around in your house. However, most folks will allow rollovers into their plan, and a lot of the issues in terms of moving that money are still things that you need to work out with a seller. The other issue, the other route you can take is to acquire the 401k plan and retain it as a standalone. And this, of course, avoids the merger into your plan, but it is frequently administratively a nightmare, and it can certainly get expensive, particularly for businesses that are regularly acquiring other businesses that are large enough to have their own 401k plan. And the last one, and really our topic here today, in terms of leaving you with some thoughts about maybe checking what you have in-house already, or keeping this in mind if you're working with a company that acquires other businesses, is the acquire and merge option. So your company acquires Target, and that Target sponsors a 401k. You assume sponsorship of it, and you merge it into your primary 401k. And that's fine. That's probably the most common option. However, as we all know, or you will now know, that any issues associated with the plan that you have acquired and are merging in, including potentially plan disqualifying issues, those become issues of your plan, which we all spend considerable time and resources keeping clean and up to snuff. So some of the concerns about the acquire and merge issue here, and the first point is really just a warning, the William Bryan Company versus IRS Commissioner case. This case involved the merger of a plan that was determined to be disqualified into the acquirer's clean qualified plan, and the result there was that the IRS revoked the favorable determination letter of the clean plan and went so far as to issue a statutory notice of deficiency that disallowed all deductions for contributions to the plan. So that's sort of the worst case scenario, what you don't want to have to go up the chain of command and explain has happened to you. The next point is, I mentioned earlier that these are hidden issues and that we see them, and that if we can give you a little advance warning, hopefully you can avoid them. But this issue tends to come up on determination letter application, in the determination letter application process. So you may be in an acquisitive company, you're buying and selling companies, merging in the 401k plans, and then when it comes time to do your determination letter for the primary plan, you run into this issue and you think, geez, I wish I'd have addressed this when we were doing the deals, and I'll touch on that at the end. But as many of you know, the instructions for the determination letter, Form 5300, as well as the revenue procedure governing that process, require the submission of plan documents and amendments through the date of the determination letter. In cases that we've seen, and this would include any plans that you, of course, have merged in since the last determination letter. And the cases that we've seen that have been particularly troublesome have involved prototype plan amendments, where the original plan sponsor was never even given copies of the amendments to sign. That was sort of automatically done by the prototype provider. And then years later, after the plan had been merged into our client's plan, the IRS on determination letter application asked for copies of the amendments, which our predecessor had itself never received. The only benefit of working with the prototype is hopefully the provider of the prototype plan is still around and can get you those documents. But it gives you the sense of the narrow-minded focus that the IRS can have in this area. And just a couple points on the determination letters. A failure to disclose material information and you cannot rely on your determination letter. There are penalties for falsifying information. In fact, there is a 1996 case on point noting that IRS penalties for falsifying information do indeed apply to the Form 5300 series for determination letters. And oddly enough, that case involved an attorney backdating some TEFRA and DEFRA amendments. And I can certainly see how that would be tempting to just change a date on an amendment, but in this case, it's not something you want to do to get your plan through the determination letter loop. There is some guidance from informal guidance from the IRS in terms of how far back you have to go. And that is noted here as the EP Determination Group's Quality Assurance Bulletin from 2006. So that may be helpful if you find yourself in this situation. If you do find yourself in this situation, and this is the thought process that we've gone through when this has come up with some of our clients, the first is, well, we need to go find the documents, and as many of you can imagine, that process starts and it moves and fits and starts, and sometimes you're successful and sometimes you're not. You can go through the VCP non-amender program, and there are some timing constraints on that, and that relates to both what the fees will be, both in terms of whether this is discovered on your application for determination letter or caught on audit, or whether you, for example, go after this call, go take a look and see if you think that you're squared away. The fees related to that process vary. You can always withdraw your determination letter request. Remember that you don't necessarily have to have a determination letter, but virtually everyone gets one, but you could withdraw it. And then last, of course, the option is to unwind everything, and that would be the Bryan disqualification option, which I suppose theoretically is an option, but it's not a very pretty one. And so what are our recommendations to avoid this issue? First, you can always don't take the plan on. So that means either in a stock deal asking the seller to terminate the plan prior to close, or you could always do an asset deal. Most of the time, in my experience, our benefits brethren don't necessarily have the lead deal position, so we may not be in a position to ask for these things to drive the deal structure. But if you find that you are and you do have that sway, then this may be something to consider. You can, as mentioned, take it on and maintain it as a separate plan, but that can get costly and become a headache. One point here, which we mentioned as a theoretical technicality, you can always require the seller to get a determination letter, although that would be entirely unrealistic, and timing-wise, I don't know that that would be the case. And that leads us to our last point, which we really want you to take away from this presentation. It's that if you do take it on and you merge it in, as most folks will continue to do, take some time to account for the cleanup costs and the risks associated with that, but also get involved in the deals, because at the time that this plan or any 401k plan comes into your system and gets merged into your plan that you spent so much time and energy keeping qualified and operating efficiently, that's the time to request all of the documentation you may need a year, 2, 3, 4, or worse down the road. So be inquisitive about deals. If you hear that they're on the, if you hear about them, to be sure that you understand what may or may not be coming in, and keep in mind that even though the deal has closed and you've merged the plan, you may still have some underlying issues there that could cause you a real headache down the road. They're certainly solvable issues, but they can be solved much more easily if addressed in advance. So, Isaac, that's I think we turn it over to Josh now.
Yes. Josh?
All right. Thanks, Isaac. Thanks, Galen. Just need to advance the slide here. All right. So as Isaac mentioned at the beginning of the broadcast, for this part of the broadcast, we'll be spotlighting Safe Harbor 401k plans. As those familiar with Safe Harbor plans will know, that the Safe Harbor plan structure has become increasingly popular since its introduction, due in large part to its at least supposed administrative simplicity. That simplicity can be deceptive, though, because there are still a number of technical requirements that can trip employers up and that can cause plans not to satisfy the Safe Harbor requirements. So today what we wanted to do was highlight a few of the potential pitfalls and suggest some straightforward ways to avoid them. First, I'd like to cover just a brief overview. The basic advantage of a 401k Safe Harbor plan is that it can eliminate the need to perform the actual deferral percentage test, that's also called the ADP test, and the actual contribution percentage test, non-discrimination test, which is also called the ACP test for elective and matching contributions. These tests can be avoided with the Safe Harbor plan structure if certain plan design elements are included. The ADP and ACP tests, of course, can be administratively burdensome, and depending on the nature of your plan's participants, they can be difficult to satisfy. So, of course, the idea of avoiding them can be appealing. To have a Safe Harbor 401k plan, the plan sponsor must agree to contribute a certain amount, either in the form of a matching contribution or a non-elective contribution. If you go the matching contribution route, the contribution must be at least 100% of elective contributions of non-highly compensated employees, up to 3% of their compensation, plus 50% of elective contributions made between 3 and 5% of the non-highly compensated employees' compensation. Alternative formulas are permitted, but they are also subject to various additional requirements that are beyond the scope of this overview. The non-elective contribution alternative is 3% of each eligible non-highly compensated employee's compensation. Since 2008, I'll just mention briefly, another type of Safe Harbor plan has been the auto-enrollment plan. These plans are also known as qualified automatic contribution arrangements, or QACAs. The minimum rate of deferrals for QACA starts at 3% of pay, and then it increases in annual 1% increments up to 6% of pay. Employer contributions are also required in the form of a matching contribution on 100% of the first 1% of deferrals, plus 50% of the next 5% of employee deferrals. Or in the alternative, the employer contribution can be in the form of 3% non-elective employer contribution. In addition to meeting these various contribution requirements, the employer who uses a Safe Harbor plan must meet certain notice requirements. These include an initial notice to eligible employees, as well as an annual notice before each plan year in which the arrangement is intended to be a Safe Harbor plan. I'll talk more about these notice requirements later on. So one might say that the various minimum contribution and notice requirements that I just described are one price of avoiding the ADP and ACP testing. Another price perhaps is compliance with the other Safe Harbor plan rules, which are less well known but which can be more stringent than the rules that apply to regular 401k plans. For example, Safe Harbor plans that aren't QACAs, the employer contributions must be 100% vested. For QACAs, employer contributions must vest 100% at 2 years of service. There are other special requirements for Safe Harbor plans that I will talk about in a minute, relating to the definition of compensation, participant withdrawals, and true-up contributions. So although these Safe Harbor plan requirements are not necessarily onerous, they're somewhat technical, and they may increasingly become subject to IRS scrutiny. In a recent presentation, an IRS representative stated that Safe Harbor 401k plan compliance was on the IRS's radar screen as an issue, and so the IRS is planning an audit initiative to investigate compliance with the Safe Harbor requirements. So given the number of technical requirements for Safe Harbor plans that I've just described, there may well be many opportunities for the IRS to find problems. So to the heart of the presentation here, some potential pitfalls for safe harbor plans. I'll just mention the four that I want to talk about briefly, and then we'll get into a little more detail. The four that I wanted to cover today are the definition and application of compensation under the safe harbor plan, the special withdrawal restrictions applicable to safe harbor plans, issues around true-up contributions under safe harbor plans, and problems with providing the safe harbor notices. So first, compensation in safe harbor plans. So one requirement of a safe harbor plan is that the matching or non-elective contributions, whichever type is selected by the employer, must be calculated based on a non-discriminatory definition of compensation under the applicable regulations. This can be accomplished by using a safe harbor approved definition or a modified version of the safe harbor definitions that is also permitted. Four of the more common safe harbor definitions are the default or long list definition, which lists out the elements of pay that are included. It includes salaries and bonuses and less obvious things like non-deductible moving expenses. There's also a short list safe harbor definition that also lists the included elements. You can use federal wage withholding. You can use W-2 wages. The regulations prescribe certain pay elements you can carve out from the definition of compensation without giving up the protection of the safe harbor, but there's not a whole lot of flexibility. The key point here is just to ensure that if you're using or if you plan to use a safe harbor plan structure, make sure your definition of compensation is non-discriminatory within the meaning of the regulations, while at the same time reflecting your goals for compensating your employees. Some potential missteps in the application of compensation under safe harbor plans. Without delving into too many of the details on compensation, I'd just like to point out a few potential missteps. One plan design that can create issues is if you have a design with multiple definitions of compensation. Say you have one definition for purposes of voluntary deferrals and another for purposes of matching or non-elective contributions. An example of this given in the safe harbor plan regulations is a plan that uses a definition of compensation for purposes of the employee deferrals that includes all compensation except overtime pay. So that's a reasonable definition. You can use that definition for those purposes, but then the plan, the example, uses a different definition for calculating matching contribution. It uses a definition of compensation that includes overtime pay. So this type of a dual definition is technically permitted in a safe harbor plan, but it would require you then to recalculate each participant's deferral as a percentage of their compensation, including overtime, to determine the required amount of the safe harbor match. So this would be just administratively burdensome and could lead to errors. So I guess our bottom line, usually our recommendation is to just generally use a single safe harbor compliant definition of compensation in your safe harbor plan for both purposes. Another area where potential missteps can and do occur with compensation is where you have a definition of compensation that is modified for some reason. You decide to exclude or include some type of pay that was previously included or excluded, and the change doesn't get fully reflected in the payroll system, or it isn't communicated timely to the third-party administrator. Although it may seem like common sense, it may surprise you how often changes to compensation definitions are not fully or consistently implemented at the ground level. So if you have a change, you want to make sure that it flows all the way through. So these types of errors in the application of the definition of compensation are sometimes hard to detect, but given the potential consequences, the loss of safe harbor status that you were perhaps counting on, it's worthwhile to try to check your plan's compliance and ferret out any errors. The last thing you want is for a participant to bring an error to your attention or worse, the IRS. Some suggestions for checking for these types of errors are to, of course, review your plan document and your SPD for the definitions of compensation, do an annual review of the plan's operations and payroll definitions, and spot check your plan's operations by taking a few participants, figuring out what their next contribution should be at the next payroll cycle, and then waiting until that payroll cycle to see if it matches what you're predicting. The next potential misstep is one that's sometimes overlooked or forgotten in practice, but it's just the idea that the withdrawal restrictions under safe harbor plans are actually more restrictive than under regular 401k plans. Specifically, hardship distributions and in-service withdrawals prior to age 59.5 are not permitted from safe harbor contributions. To avoid running afoul of these restrictions, plans should segregate the contributions into two buckets, one for safe harbor contributions and the others for the other bucket for contributions not subject to those withdrawal restrictions, so that you don't inadvertently permit a withdrawal that is not permitted under the safe harbor regulations. A third misstep that can come up in safe harbor plans relates to the calculation of matching contributions and the restrictions on whether you can true up contributions that are not made for one reason or another during the year. The safe harbor, so just by way of background, the safe harbor regulations permitted an employer to choose whether to make the safe harbor matching contributions on a payroll period basis or an annual basis. If the employer uses the payroll period method, they are not required to make additional contributions at the end of the year to take into account the total amount of the participant's compensation for the entire year, so long as a special timing requirement is met. The timing requirement is that the safe harbor matching contributions must be contributed to the plan by no later than the last day of the following plan year quarter. Because true-up contributions are not required, even if you're using a payroll period method, a participant could receive a match for the year that's less than the full match percentage on the participant's compensation for the year. To illustrate, say, for example, a company provides safe harbor matching contributions that match dollar for dollar on the first 4% of a participant's deferrals. Employee A, let's call her Amy, defers 8% of her salary for the first half of the year, but then she revokes her election and contributes 0 for the second half of the year. So what would her matching contribution on a payroll period basis be? Well, if the plan calculates the safe harbor matching contributions on a payroll period basis, she'll receive an effective match of only 2% of her compensation. So this is because for the first half of the year, when she's deferring 8% of her salary, her first 4% was matched dollar for dollar, and the next 4% went unmatched because it exceeded the matching limit. What would Amy's matching contribution have been on an annual basis? She would have, her entire amount of deferrals would have been matched because her total deferrals for the year would equal 4% of her annual compensation. So even though a true-up to the 4% of compensation is not required if a plan uses a payroll period basis for matching contributions, some employers will consider giving one anyway. The cautionary note we want to sound for today's purposes is that if a true-up is made, it generally must be uniform among participants. For example, the true-up could not be provided only to highly compensated employees whose contributions had stopped mid-year, not because they had revoked their elections, but because they had reached the 402G limit on deferrals for the year. So in our example, if Amy had maxed out under 402G during the first part of the year and received only 2% of her annual compensation as a result, if her employer trues her up to 4% of her actual compensation at the end of the year, the employer must true everyone up on the basis of their full year compensation if they were otherwise shortchanged. The final safe harbor plan error we want to mention today is it relates to safe harbor notices. These notices are required to include details on the employer contributions that will be made, other contributions under the plan, the type and amount of compensation that may be deferred, information on withdrawal and vesting provisions, and certain other prescribed information. The employer must provide the notice to newly eligible employees within a reasonable period before they become eligible, or immediately when they become eligible, but it's typically 30 to 90 days before eligibility is considered reasonable. And they have to provide a notice annually to all participants within 30 to 90 days before the beginning of each plan year. The notice requirement is important for several reasons. Among other things, the IRS will examine plans for compliance with the notice requirements. The IRS will look for what it considers to be telltale signs of noncompliance, such as low deferral rates among eligible employees, inadequate plan procedures for issuing the notices, or an absence of records showing that the plan procedures for issuing the notices were followed. The corrections for a failure to provide the notice include potentially making the participant whole for missed deferral opportunities and missed matching contributions. So it can be costly, and it's important to make sure the notices are provided. In addition to the possibility of having to make those corrective contributions to plan participants, DOL regulations can impose penalties for failure to provide disclosures, such as the automatic contribution notice that's required for QACAs. That can be as much as $1,000 per day. With that, I will conclude today's spotlight on safe harbor plans, and I will turn things over to Robert.
Welcome, everyone. I am going to talk about the new Department of Labor fee disclosure rules. And I want to stress that despite having a lot of slides to look at and a lot of information, this is really just a summary of the rules. And so it's very important, I believe, to make sure that you have a good comfort level with all of the rules, because they significantly affect the duties and responsibilities, including the fiduciary liabilities of plan fiduciaries, plan sponsors, and so this really is a big deal. And as the beginning slide indicates, since ERISA was enacted many, many years ago, one of the real problems that plan sponsors and participants have faced is how to assimilate the information and how to understand the information regarding all of the various fees that are associated with the administration of their retirement plans. And so after all of these years, it has triggered new disclosure requirements, and there's two separate types of disclosures that are going to be required very, very soon. The first being the disclosures by all of the various service providers to the plans and plan fiduciaries, and then secondly, the various disclosures that are required to be made to plan participants. The new rules were published by the Department of Labor earlier this February. The first set of disclosures, which would be the ones from the service providers, become effective on July 1 of this year. And so in order for the various arrangements to be considered reasonable, the arrangements between the service providers and the plans, in order for them to be considered to be reasonable, these rules must be complied with. In other words, the service providers have to make these disclosures to the plans and plan fiduciaries. Otherwise, these relationships would constitute prohibited transactions, which can be subject to penalties under ERISA, as well as excise taxes under the Internal Revenue Code. And then as I say, the second type of disclosure, that deadline, this is the one for participants, that has to be satisfied by the end of August this year. In order to make sure that things are moving along well with your third-party service providers, there are a lot of plan sponsors who have taken it upon themselves, and I think this is a good idea for them to contact their service providers now to make sure that they're on schedule for that July 1 deadline. and these disclosures may be made electronically. For the disclosures that are going to be made to the plans, the types of plans that are subject to these rules are all qualified plans, both defined benefit and defined contribution. That would include, by the way, 403B plans that are subject to ERISA, but if the plan has been frozen since pre-2009, those are exempt. But for all other ERISA 403B plans, these disclosures are required to be made to you. As I'm also going to mention later, even though these rules technically do not apply to plans that are not subject to ERISA, I think it's very prudent to make sure that these rules are adopted and that people here who are listening to this but who are not involved with ERISA plans still should be aware of them, because if something goes wrong and there is misinformation, there's not adequate disclosure, I don't believe it's much of a defense to say that the plan was not subject to ERISA, because there are state laws which basically emulate these rules, or would, and state court judges would certainly use these rules, the ERISA rules, as a model for them to follow. So these contracts to provide services to employee benefit plans, again, defined benefit and defined contribution, the services provided must be subject to reasonable fees, and the failure to charge reasonable fees, again, subjects fiduciaries and others to significant penalties. There is a $1,000 threshold minimum, but as you can see from the list in the second bullet, there is a wide spectrum of the types of services, all associated and all that you would expect to be associated with the services that are provided to covered employee benefit plans. There are distinctions made in the types of disclosures between direct compensation as well as indirect compensation. Direct compensation is the compensation that is paid directly from the plan, whereas indirect compensation, which is probably deserving of a little more scrutiny by all involved, because that involves compensation to the service provider, not from the plan, but from some third party. And so it probably introduces the potential for more conflicts of interest, and certainly deserves greater scrutiny when third parties are paying your covered service providers. For the first time, these relationships will have to be disclosed, and the plan administrators will learn, again for the first time, the nature of the compensation as well as how much is being paid to them. Another type of disclosure which you commonly see with contracts with insurance companies where they are the vendor is what happens if there's a plan termination. Often insurance contracts provide for termination fees. And so any service provider who expects to serve as a fiduciary is required to furnish a statement that he or she will be serving in that capacity, and that information must be disclosed. That fact must be disclosed, and notwithstanding the fact that sometimes in contracts third-party service providers attempt to, by contract, claim that they are not fiduciaries and therefore under these new rules would not be subject to them. And so a person is or is not a fiduciary based on the services and their relationship to the plan, not whether a contract happens to state that they are or not a fiduciary. So we've got an upcoming deadline, and I believe it's prudent for people involved with the administration of retirement plans to contact their service providers now, if they haven't already done so, to confirm that that the service providers intend to meet their deadline. As a remember, the whole point of this is that the plan administrators need to understand whether or not, or at least form a judgment, whether or not the compensation they are paying for their service, for these services, is reasonable. They need to know whether there are conflicts of interest, and they also need a lot of information to make sure that they can report on their Form 5500 all of the information needed for that form, and this is the source of that information. So this deadline is very important. The Department of Labor regulations state that in the event of incomplete or inadequate disclosures, then there is a responsibility on the part of the plan fiduciary to notify the service provider of this. And service providers will then have 90 days to respond. And for the first time ever that I can remember, there is a system now in place whereby the fiduciary must notify the Department of Labor if they have not received this information on a timely basis. And then after the July 1 deadline, after that disclosure is made, these disclosures will continue and be required each year. There's an annual requirement for them. Just a few thoughts on this, in this, because I know a lot of our clients are involved with multi-vendors, and it would probably defeat the purpose of these new rules if plan fiduciaries received a multitude of disclosure documents, and because of the difficulty in understanding and putting together this and comparing the various charges that certainly that the vendors performing the same services are providing. So the Department of Labor rules have now require that these disclosures be aggregated where there are multi-vendors, and so I haven't seen this yet, but I would assume that plan sponsors will be asked by the vendor that is going to compile and aggregate this information. There's probably going to be a fee associated with this. And there's also, I would say, been a concern raised about this rule, about what is required of the vendor that is going to be responsible for doing this. Can they simply staple together some reports and disclosures that other vendors have made? Is that going to be adequate? What kind of format it will be required in order to assimilate this information? These are unanswered questions, and hopefully they have been raised already with the Department of Labor, and hopefully there will be responses forthcoming from this. And I'm sure there are people who are listening on this call who are at least partly responsible for the compilation of that information. So again, the whole point of this is to make sure that the services that they're paying for are being provided for on a reasonable fee basis. It's maybe very difficult for people to make an assessment about what is a reasonable fee. For example, if one vendor provides excellent service, does that justify a higher fee, or does the fact that someone else may be providing a similar service but charging a lower amount, albeit perhaps with a lower quality of service, is that a fair thing to factor in? I would also mention the recent ABB case, because that's a fairly sobering case that raises some important issues for you, and it's a brand new case. And certainly one of the reasons it is so important is because most of these the reasonableness of fee cases, most have been settled, and so we don't really know how the parties reached the agreement they did. But this actually went to trial, and the fiduciaries of ABB were determined to have breached their fiduciary duties because they did not monitor record-keeping costs. In this case, it happened to be Fidelity. They could have, but failed to negotiate from Fidelity's and certain other vendors various rebates from them. They also selected more expensive share classes than they had to. The other ones were available to them. And lastly, they also agreed to pay Fidelity for amounts that exceeded the market cost for these services in order to get discounted services, but not for the benefit plan, not for the retirement plan, but instead for other services that Fidelity was providing to this company. And here's the really sobering part. A judgment was rendered against these fiduciaries for $13.4 million. And those, of course, were, this case was decided before these new rules went into effect. So now the second set of disclosures are the disclosures that the fiduciaries will be required to make to the participants. And there are, under Title I of ERISA, there are exclusive benefit rules and prudence rules that require plan fiduciaries to furnish participants with the information they need in order for them to carry on their investment and management responsibilities in an informed manner. And never before has this kind of information really been required to be provided to them. Now, unlike the disclosure requirements that I talked about before, which was the disclosure rules for service providers giving to fiduciaries, these rules only apply to individual account plans, so therefore this would not cover defined benefit plans. And again, non-ERISA plans like governmental and church plans are also not subject to them. But again, that doesn't mean that if you are involved with the administration of one of those types of non-ERISA plans, that you can ignore these. I again urge you to consider following them to the extent that you would if you were subject to the new rules under the Department of Labor. So the deadline now for the initial disclosure to plan participants is this August. There are three major categories of information that have to be provided to them. I'm going to go over them fairly briefly now. But you have to disclose to your participants the circumstances where they can give investment instructions, a description of the various investment options available to them, who the investment managers are, and if there is a brokerage window, that and many 401k and 403b plans offer these today, a description of those windows and how they operate. The second broad category is the types of administrative expenses. They need to be explained to them, and these are the types of expenses that are imposed on a plan-wide basis. The typical kinds of expenses that you would expect would be record-keeping, legal, and they have to. The description has to explain how they're to be allocated amongst participants. The third category is where you have individual expenses, and there must be disclosure where charges against the individual's particular account are going to be made where they're not charged to others. And as you'd expect, these would be if the individual is subject to a quadro, a qualified domestic relations order, or if the individual is applying for a loan, as you'd expect, it's reasonable to charge that participant. And these disclosures are required to be made on a quarterly basis. So there are, I know we're getting a little light on time, so I'll try to finish this up. But we do have, for the various investments, some terrific information to allow participants to assess the reasonableness of these costs. And so for each investment choice, you have to have certain information regarding those investments, how the performance of the fund has done, the various fees and expenses associated with that. And the new rules also require that they be presented in a format that an average participant can reasonably understand what they're seeing and to be able to compare that information to other funds also that are offered under the plan. And thankfully, the Department of Labor has offered made available a model comparative chart to satisfy that requirement. So just some final thoughts to leave with you. We have, of course, a lot of plans that use just a single vendor. Sometimes, and actually fairly frequently, you have multiple vendors. And I don't think there's an answer to this, but sometimes the pricing can be affected by the existence of other vendors. You can, I think, if you think about it, you can find reasons why, in either situation, why the costs may be greater, why it may be more efficient to use a single vendor. It is a significant burden on the plan fiduciary to interpret the various information that you're going to soon receive from the service providers. And so it's not too soon to start thinking about how you're going to do this. One of the ways probably is to consider hiring a consultant in order to help you with this information. There are consultants out there, we've been working with them, who are looking into the various costs associated with the maintenance of a plan, and sometimes they have some very good ideas and are able to present the information to you in a much more understandable way than you might have thought. Again, just some more final thoughts. One of the burdens that has been recognized is, how do small employers afford these costs? There is no answer to this, and so in fact the answer is probably no, but nevertheless there is no carve-out for them. So this is certainly one of the costs of sponsoring the plan, is dealing with these new rules. And something that I'd already mentioned was the fact that even for non-ERISA fiduciaries, there's still a lot to think about for them as well, because of the fact that state laws will undoubtedly require, and state judges will undoubtedly subject them to the same level of scrutiny and the same types of questions about whether they acted reasonably under the circumstances, despite the fact that they can't point to the Department of Labor rules as ones that they have to follow. That concludes my presentation. Again, I appreciate the opportunity to have spoken in front of you and stress that there's a lot of information out there, and unfortunately the Department of Labor didn't give us a lot of time in which to digest it. Thank you. I think we can take some, Isaac, I think it's time for some question and answers.
Yes, thank you. Thanks, Robert, and thanks to everyone who's been presenting today. We do have a few questions. It looks like we'll probably have time for one or two. But Josh, it looks like the first question comes your way, and the question deals with what you were talking about on the safe harbor notices, and basically asking for the initial safe harbor notice, what happens if the notice is not provided to a newly eligible employee in time for their first day of eligibility? Maybe you could speak to that a little bit.
Sure. Yeah, that generally, the timing requirement, as I described, is that the notice be provided to eligible employees in time to allow them a reasonable opportunity to make their deferral election. So this typically means on or before the date they first become eligible, but there are circumstances where it's not practicable for one reason or another, and in that situation where it was not practical to get the initial notice to them within the required time frame, the regulations will treat the initial notice as timely if it's provided as soon as practicable after the employee becomes eligible, as long as the employee is permitted to defer from all of the compensation that they earned beginning on their original eligibility date.
Okay, good. So it sounds like there's a little bit of room there in case that situation happens. And I'm gonna feed you one more that I think was relevant to what you were talking about, and that is, and I was thinking about this as well. Maybe you could speak a little bit to the issue of how catch-up contributions are treated under a safe harbor plan.
Sure. Yeah, it's a little bit different from your non-safe harbor plan. If a safe harbor plan has implemented catch-up contributions and they're relying on the matching contributions to satisfy the ADP safe harbor, the plan must match the catch-up contributions to the extent that non-highly compensated employees wouldn't otherwise receive their full safe harbor matching contributions if they didn't receive the match on the catch-up contributions. So kind of a special treatment under safe harbor plans for those.
Okay, great. Well, I know we have a couple more questions, but I want to make sure that we let everybody go on time today. So for those of you who did submit those additional questions that we haven't had a chance to answer, our presenters will get back to you either by email or phone after the broadcast ends. I just want to give you a couple of quick ending reminders here. The first one is that we still have 2 more broadcasts left this year. The next one happens near the end of July, on July 24th. We hope you will join us for that. And then, as always, a copy of these slides, as well as the audio from this broadcast, will be available on our website within a few days. So you always have the opportunity to go back and get a copy of the slides again, or to go back and review all or any portion of the presentation. And then again, as I mentioned just at the beginning, we really do welcome your feedback, so we hope you'll take just a few minutes to take this survey. We do review the comments that you give us. And if you have ideas or topics that you would like to see covered for subsequent broadcasts, please let us know. We do our best to stay on top of things and to cover new items and to cover things that we see coming through a lot. Again, if you have something that keeps hitting you, let us know so we can make sure that gets covered as well. And with that, I just want to thank everybody for attending and look forward to seeing and hearing from you again soon. Thank you.
Ladies and gentlemen, this does conclude today's conference. Thank you for your participation and have a wonderful day. You may all disconnect.